of questioning from the gentleman from Iowa and Texas before then. We're going to try to make it all work and be good stewards of your time in the process. Within the Department of Justice, the Executive Office for Immigration Review is charged with overseeing the immigration courts and the Board of Immigration Appeals, which is the highest administrative authority for interpreting the immigration laws. As the delegates of the Attorney General, immigration judges serve an important function in the administration of our immigration system. They award asylum to those fleeing persecution. They grant deserving aliens the privilege of permanently residing in the United States. And they also order remove those aliens who have violated our laws and abused the generosity of this nation. Whether our law requires immigrants to return to their native land or whether it affords them an opportunity to stay in this country will depend upon the ability of the immigration judges to faithfully apply the law that Congress enacted to their cases and to exercise their impartial judgment unhindered by political agenda. Because of the relative obscurity of immigration courts, their labors largely go unnoticed and you could argue unappreciated by the American public. But their decisions affect real people, the immigrants and their family members alike, and their effect on the immigration system is critical. Everyone, those who stand before the administration judges, this administration, and our fellow citizens, has a vital interest in ensuring justice in our immigration courts is dispensed fairly, efficiently, and expeditiously. That is one reason I am troubled that there are approximately 460,000 cases waiting for an immigration judge to make a decision. In addition, I remain troubled by allegations of abuse, fraud in the asylum program. Abuse and fraud, frankly, hurt everyone, those legitimately entitled to relief and those who depend upon a fair justice system. The average alien will wait nearly 3 years before the judge renders a decision, and those are the fortunate ones. According to the 2012 DOJ Inspector General report, over 21,000 cases were pending 5 years or more, and over 6,200 cases were pending for 10 years or more. The real effect of these delays is to penalize those awaiting relief based on a valid claim to immigration benefits and reward those who have no right to remain in the United States with many years of continued unlawful presence. A testimony before the Senate earlier this year indicated the backlog had increased 100% over the last 5 years, and the answer to the problem was alleged to be more immigration judges. But the DOJ Inspector General found from fiscal year 2006 to 2010, while the number of immigration judges increased, case completions actually decreased. So the Office of Inspector General found inefficiencies persisted despite the addition of more immigration judges. The Inspector General also noted incomplete or exaggerated performance reports and noted the absence of the data or an objective staffing model to guide its resource planning and deployment of immigration judges, which begs the question as to whether or not additional immigration judges alone will solve the problem or if something else is required. Additionally, a report by the Government Accountability Office released yesterday found derelictions in implementing the necessary policies and procedures to address asylum fraud. The lack of focus on rooting out fraud in the asylum program, coupled with a backlog that allows people to stay in the country unlawfully through the long backlog of cases until their court date, is a gap in our national security. The bottom line is an inefficient and flawed adjudication process further diminishes our capacity as a nation to effectively deal with our broken immigration system. And for that reason and others, I'll look forward to today's questions and answers. Again, I will recognize Ms. Lofgren and Mr. Conyers whenever they come, but I will begin by recognizing the gentleman from the great state of Texas for his questions, the former United States Attorney, Mr. Radcliffe. Gentlelady yields back. Chair will now recognize himself. Director, I wanted to ask you about the Inspector General for the Department of Justice, but my friend from Texas' line of questioning prompted me to want to go a little further there. I'm going way back in time to a period where I wasn't all that knowledgeable even back then, so I'm less knowledgeable now. But if memory serves, the government and the defendant can consent to a bond. It doesn't necessarily have to be adjudicated by a judge, does it? Or is immigration different?
You're talking about a bond, sir?
Bond.
The bond process, what I think happens is that ICE actually makes the first determination on bond when they are detaining an individual. And in some instances, that individual can then request a redetermination by an immigration judge.
Well, You had a line of questions with the former U.S. Attorney in Texas about the 33 who were charged with homicide, I assume. Well, homicide's not a charge in South Carolina. Murder, some form of murder. I'm just wondering whether or not the government consented to bond in any of those cases, or whether or not you've had a chance to look at that.
I believe in the majority of cases, the judge made the determination on bond, and the Department of Homeland Security did not appeal that determination.
All right. In the area of appeal, I think you mentioned the standard for continuance is good cause.
Correct.
Can you cite me to any opinions of record where a judge was reversed for granting a continuance?
I can't cite you any particular cases, but I do know from my experience when I was on the Board of Immigration Appeals many years ago that judges would get reversed for granting too many continuances when the DHS appealed that decision.
Well, good cause is probably hard to define despite the efforts of courts to do so. What would be a reason not to grant a continuance?
It depends on the individual case, but for example, if a judge has granted a couple of continuances already for the individual to get counsel, and the individual has made no reasonable efforts to secure counsel, a judge can very well and often do say, you know, I've given you a couple of chances here, it's time to move on, and judges make those decisions every day. That's a fairly frequent occurrence.
Speaking of frequency, is the first continuance fairly much for free? I mean, do you get the first continuance just simply by asking for it?
Again, it depends on the context. In detained cases, it's not that way, and non-detained cases, it can be in some courts, depending on what the situation is.
All right. You mentioned the factors that the court considers in either detaining somebody or setting bond, the flight risk and the danger to the community, which prompts me to want to ask about folks who abscond. What percentage of folks fail to appear for their court date after a bond is set?
I don't have that number for you, Mr. Chairman. Some do fail to appear. The size of the bond is designed to make sure that they appear, but you know, some sometimes don't.
I'm with you, Director. I used to live it, but from where I sit, the number of folks who fail to appear would be a pretty serious issue. I'm assuming you don't try them in their absence.
Well, actually, they do. There is a process for if somebody has received.
You have to prove they got notice.
If they got notice of the hearing.
Okay.
The law does provide, and our judges every day hold hearings in absentia. What happens at that hearing is that the Department of Homeland Security comes forward, presents evidence of the individual's removability. The judge considers whether the person got adequate notice. If the answer is yes, then the judge will order an in absentia order, and that order can be enforced by the Department by DHS.
All right. If somebody fails to appear, what is the mechanism by which you compel their appearance? Do judges issue bench warrants?
No, our judges don't have that authority. We don't have anything like the Marshal Service or anything like that. The judge will consider if the person got adequate notice that they will issue the in absentia order if it's appropriate, and then DHS has the responsibility of picking them up and actually removing them.
Of your backlog, what percentage would you say are folks who absconded or failed to appear after a bond was set and a trial date was set?
If they have received a final removal order in absentia or otherwise, they're actually not included in the 450,000 caseload. Those are out of the system. There's a final removal order. Unless they file a motion to reopen later to come back in and the judge grants that, in absentia orders or any removal order is not included in that number.
All right. Given your background and your expertise, what percentage of folks who abscond are tried in their absence?
Sorry, you're asking how many folks that don't
fail to appear or tried in their absence?
Actually get in absentia orders?
Yes.
I don't have that number for you. I just don't.
What other tools do you have other than trying someone in their absence? If there's a failure to honor a court date, what other tools do you have? You don't have a bench warrant. There's no presumption that is lodged against that. There's no evidentiary presumption, I would assume. You can't. I mean, can the judge consider the evidence of flight as some evidence of guilt or consciousness of wrongdoing if they don't show up?
No, what the judge will consider is whether the person actually is removable from the country under the law, and that's really the end of the inquiry. Once that is done, the removal order is issued, and then the person can be removed, can be picked up at any time by ICE and deported.
Let me ask you one more question, and I'm going to let the Congresswoman follow up. I assume DOJ Inspector General is still Michael Horowitz?
It is.
I got to tell you, he's from where we sit, he's a pretty good balls and strikes caller. He's a fair guy. All my dealings with him, he's been kind of straight down the middle. So when I see that he has concluded that even as the number of judges increases, the disposition number of those judges decreases, that catches my attention, because it makes me think maybe something else is going on and it's not just more judges. I don't want to minimize. I mean, if that's the explanation, then that's the explanation. But when Mr. Horowitz says that may not be the full explanation, what else could be going on?
Mr. Chairman, I do think that the single biggest reason for the caseload is the shortage of judges over the last few years. I don't think that you can lose as many judges as we did at a time when enforcement was going up and not have that be a significant impact on the caseload and on wait times. We have taken a look at this issue repeatedly. We've kicked the tires. We've looked under the hood. We have tried to see what else is going on. One thing that we do hear quite a bit from all of our judges and from ICE trial attorneys as well is that the complexity of the law has gotten much more complex over the last 10 years. Cases that used to be fairly simple are now complicated. Let me give you an example. It used to be fairly straightforward to determine whether somebody is an aggravated felony under certain provisions. Because of Supreme Court precedent and other decisions, in many instances, the drug trafficking area is one, for example. It is actually much more complicated these days than it was 10 years ago to determine whether somebody is deportable as an aggravated felony for certain offenses. So that is one area that we have concluded, a judge may have spent, an hour on a case 10 years ago, and that same type of case now may take 4 hours because the law has gotten more complicated. We've taken a look at other issues as well, but we're convinced that that hiring the requisite number of judges is actually going to make a difference. And let me actually give you an example, or from actually within the agency, and that's the Board of Immigration Appeals. The BIA is doing very good decisions these days, very legally excellent decisions, providing guidance to the courts, and their caseload is stable. In fact, it has actually decreased slightly over the last few years. The lesson that we took from that is that the board has actually had, unlike the immigration courts, a balance between the incoming caseload and the adjudicators necessary to adjudicate that caseload. That's the lesson that we've drawn, and that's why hiring is such an important priority for us, for the immigration courts, because we are convinced that that is how we will address this caseload.
Recognize the gentlelady from California.
Thank you, Mr. Chairman. Just a couple of follow-up questions, if you could get back to us on it if you don't know now. I would like to know what the failure to appear rate is on various categories. Looking at some of the data, it's very low. If individuals are represented by counsel, there are different outcomes if someone isn't. And so if you're able to make those distinctions, I think that would be helpful. I'd like to know, among the 30 who committed homicides or were charged with homicides, how many of them were Zadaeus case releases or not? And among the, if they were Zedeas case releases, how many of them were Cubans? And with the change in status between the United States and Cuba, there's apt to be, I mean, the last time we looked at it, the vast majority of the Zedeas cases were Cubans. And if they are removable to Cuba because of our new relationship with Cuba, we're going to have a very different outlook in terms of the criminal issues and Zedeas. And then I just wanted to clarify for the chairman and others in terms of notice, because there's no requirement that the person receive actual notice. I mean, what you're looking at in the court is, was something mailed to the person? I mean, that person could have moved. He might never have lived there. We had a case a number of years ago of a legal permanent resident who failed to file the removal condition on her marriage, who was active duty Navy in a uniform, who was mailed a notice, never got it because she was deployed to Kuwait, and was found deportable in absentia because it was something she never heard of. So I think it's important to note that it's not like the criminal courts or the civil courts. You're not getting, you know, a server handing you the notice. It's just in the mail, and you may or may not even know what's going on. Thank you, Mr. Chairman.
Thank the gentlelady. Would recognize the gentleman from Texas for any concluding remarks he may or may not have, and he is indicating that he is done. So this concludes today's hearing. I want to thank you for attending. I want to tell you again that the fact that folks may have been in and out or not able to come is no reflection of the seriousness with which they take this hearing. Fly-out days are always troublesome, but that's on us and not on you. You were here like you were supposed to be. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. With that, we thank you for your testimony this morning and your willingness to answer our questions, and we will be adjourned.
Thank you, Mr. Chairman.